Hi friends, this is Naganand. I am going to dictate a passage at 80 words per minute for 5 minutes. 5 seconds left. Start. Even on merits, I am inclined to accept the contentions that the checking officials ought to have checked the cash balance with the petitioner even in the absence of any such plea raised by the petitioner. Had the checking officials checked the cash balance with the petitioner, the issue of the petitioners collecting requisite fare and not issuing the ticket would have been clinchingly concluded. The Labour Court has also further observed that it is not the evidence before the domestic enquiry but the material on record that has to be considered. I do not, however, see any distinction, much less contradiction in evidence and material on record. The spot statements of the passengers can't be elevated to be placed on the pedestal of inviolability as was done by the Labour Court. The delinquent workman is always at liberty to contest the every statement made by either the passengers or by the officials of the corporation, though the learned counsel for the petitioner has laid much emphasis on the fact that passengers who gave the statements were not examined during the course of domestic inquiry. There can't be any universal principle established that in each and every departmental inquiry, the passengers from whom the spot statements were obtained should be examined. It is, however, entirely a different thing if the findings during the course of disciplinary inquiry are entirely based on those statements of the passengers without there being any other material to bring home the misconduct of the delinquent workman. In other words, the spot statements made by the passengers in the absence of their examination in the domestic inquiry could at best be used as corroborative evidence but not sole evidence to establish the guilt of the delinquent workman. In this instance, the checking officials, that is TTIs, have deposed that the petitioner collected the fare from the passenger but did not issue the ticket. With equal vigor, the petitioner in his defense denied it. It is not the case of the corporation that the petitioner has admitted his lapses during spot check and later retracted it. Neither can we find any telltale signs of the misconduct of the workman left on the record which are apparent without even the aid of passenger statements. Though the allegation on the part of the petitioner that he was forced by the checking officials to close the SR was rightly disbelieved by the authorities without any further material on record. Stop.